Welcome back. Here's part 2. Let's finish this up. All right, we're going to pick up where we left off, and that is with the crime of prostitution. It's important to remember. I wonder how many times I've said it's important to remember between part 1 and, well, there's probably going to be a lot more in part 2. So the important thing to remember about prostitution is there's actually 3 crimes that relate to prostitution. One is soliciting a prostitute. That's asking a person to engage in sexual activity in exchange for payment. It's also called patronizing a prostitute. That's one crime. Soliciting a prostitute, also called patronizing a prostitute. That's different from the second crime, which is promoting prostitution. Colloquially, this is known as pimping. This is arranging for someone who's working as a prostitute to connect with a customer, someone who's going to pay them money in exchange for sex. So that's promoting prostitution. And the third crime is actually prostitution, which is committing a sexual act in exchange for payment. So if someone were to commit to a sexual act in exchange for payment, they could be charged with prostitution. If someone is connecting a prostitute to a customer, that is promoting prostitution. And if a person is asking someone or engaging with someone to have sex with them in exchange for payment, that is soliciting a prostitute. There's been some confusion on this, so I want to make sure that it's clear which is which. Soliciting a prostitute, which is also called patronizing a prostitute, promoting prostitution, and the act of prostitution. And remember, payment's not just cash money. It could be drugs or anything of value. Prostitution and sex trafficking are not the same thing. It's critical to note that prostitution and sex trafficking are not the same crime. Sex trafficking is getting someone to engage in sex acts for payments by use of force, fraud, or coercion. That's one definition of sex trafficking. The second definition of sex trafficking is getting any person under age 18 to engage in sex acts for payment. An example of getting someone to engage in sex acts for payment by use of fraud is someone telling a person that they'll get them citizenship or a job if they engage in sex acts for money. An example of coercion is threatening to hurt someone if they don't agree to engage in sex acts for money. So that's sex trafficking by force, fraud, or coercion. Or it's getting any person under age 18 to engage in sex acts for payment. Getting someone age under 18 to engage in sex acts for payment is not prostitution. Promoting prostitution involves connecting a customer to a prostitute who is over 18. That's promoting prostitution, or what's colloquially known as pimping. If someone is involved in getting a person under age 18 to engage in sex acts for payment, that's sex trafficking. Let's move on to drugs. We talked about the federal drug schedules. This is the categorization of drugs by the federal government, most notably the DEA, the Drug Enforcement Administration, and the FDA, the Food and Drug Administration Agency. They work together to classify drugs on a schedule. Schedule 1 is the most dangerous drug, the drugs that are most likely to cause problems with addiction, and it moves down to a Schedule 5 drugs, which are the drugs on the list least likely to be abused or to become a problem with addiction. So Schedule 1 are the most serious drugs. And I know you can't see this very well, but remember, this was a handout. I sent this to you via email. And if you need a copy, it is on Blackboard under handouts. I know the visual here is not great. So in the Schedule 1, the most dangerous drugs classified by the federal government is heroin, LSD, ecstasy, and to some people's surprise, marijuana. The federal government has classified marijuana as a Schedule 1 drug, meaning that is an extremely dangerous drug and has a high likelihood of addiction. That is the federal government's classification of it. This is why the federal government cannot legalize marijuana, because they have classified it as a Schedule I drug. So in order for the federal government to legalize marijuana, the first thing they would have to do is reclassify it. So that's one of the reasons the federal government can't say marijuana is legal, because they've classified it as an extremely dangerous drug with a high likelihood of addiction. When we got talking about legal marijuana in the mixed states, which we'll cover in a second, it brought up some questions about federal property versus state property. So imagine it this way. Colorado is one of the first states, if not the first state, to legalize marijuana for medical, recreational, for any purpose. You can have and possess marijuana in the state of Colorado. So the DEA is conducting an investigation in Colorado. If a person is using marijuana, growing marijuana, or selling marijuana on Colorado state property, the Drug Enforcement Agency could not arrest someone and say, well, we're federal officers and it's illegal on the federal level. If they are complying with state law on state land, they could not make that arrest because, of course, it's legal there. However, if you were on federal land in the state of Colorado, say, for example, you were in a U.S. Forest Service national park located within the state of Colorado, and you had marijuana, were growing it in that state park or selling it in that state park, you could be arrested because that is federal land. This doesn't come up a whole lot, but just to be technically correct, that's the way that works. We talked about marijuana across the United States. These laws, as you know, are changing frequently, but as of right now, spring semester 2020, in the United States, there are 11 states that have declared marijuana is legal for both medical and recreational purposes. 11 states. There are still 11 states that have declared marijuana to be absolutely illegal. It cannot be used, grown, distributed, possessed for medical purposes. Same applies to recreational purposes. It's absolutely illegal. And then there's 28 states that we call mixed. And if you read articles or look at the marijuana advocacy websites, they talk about mixed states. And mixed states you have to be careful with because it means marijuana is legal for some people, some of the time, for some purposes. So you have to be really careful if you're using marijuana and you're traveling that you know what the specific laws are in those mixed states because that can get confusing. So you need to remember 11 states completely legal, 11 states completely illegal, and the remaining 28 states have a mix of laws. We had a major change with marijuana in New York State just last year. So before June 2019, before June of last year, even small amounts of marijuana had criminal penalties. For example, if you had less than 25 grams, and you see that in the top of the photo, it's just a pinch of marijuana slightly bigger than a quarter. Less than 25 grams was a violation. We remember from our part 1 that violations are not crimes. Violations are infractions, or also called summary offenses. So if you had less than 25 grams, you would be charged with a violation, basically given a ticket. You'd have to pay it. You may or may not have a court date, and you would not get a criminal record. But remember, 25 grams is an extremely small amount. It's about the weight of 2 paper clips. So it's an extremely small amount of marijuana that prior to June 2019 was not criminalized. If you had 2 flakes more than 25 grams, which is a pinch just larger than a quarter, that was a crime. That was criminal possession of marijuana in the 5th degree. That was a Class B misdemeanor, which came with a penalty of up to 3 months in jail. And most importantly, it created a criminal record. So if you were applying for a job and it says, have you ever been convicted of a crime? You would have to say yes if you had been convicted of having over 25 grams of marijuana. And that could have been just a teeny tiny bit over 25 grams. that would give you a criminal record. If you had over 2 ounces of marijuana, which if it's hard to see the height of that pile in the picture because I had it on a plate, but imagine a sandwich bag, just a regular size sandwich bag, and filling it completely full of weed, just as much as you could pack in it. That's about 2 ounces. If you had that much weed on you before June 2019 in New York State, that was criminal possession of marijuana in the 4th degree. That was a Class A misdemeanor, which of course means you could have gotten up to a year in jail and or $1,000 fine. And again, really important to emphasize, it would result in a criminal record. And of course, if you had more than 2 ounces, the penalties just got higher and higher into the felony level. So that's how things stood in New York State before June of 2019. And what the legislature did after June 2019, it became effective, was they did what they called decriminalized small amounts of marijuana. So currently in New York State, an adult may possess up to 2 ounces of marijuana and only receive a violation. The penalty is between a $25 and a $50 fine. And most important to the advocates who really worked very hard for years to get this law changed, you don't get a criminal record. So it is accurate to say New York State has decriminalized small amounts of marijuana. And what the legislature has determined to be a small amount is 2 ounces or less. Now, we're not talking at all about growing that amount of marijuana or selling that amount of marijuana. So make sure you're clear about that. This is simple possession. This is you have this on your person. In New York State, you can now have up to 2 ounces of marijuana. It's only a violation. You get a small fine, and you do not have a criminal record. So it is not correct to say small amounts of marijuana are legal, because if you have less than 2 ounces, you can still get a violation. So it is not legal. It has been decriminalized, small amounts, and possession only. If you have any questions about that, please send me an email. We also went from drugs to alcohol. We talked about 2 major national changes in the 1980s. Of course, we talked about historically, there was actually a constitutional amendment that prohibited the sale, transportation, or possession of intoxicating liquors, which was ultimately repealed, and I think in 1933. Don't really need to know that for the final exam, but it is important to know that laws regarding alcohol use, manufacture, and transportation have been on our records since the late 1800s. There were 2 major national changes in the 1980s involving alcohol use. The first was in 1980, a woman whose daughter was killed by a drunk driver created what we call MAD, which is an acronym for Mothers Against Drunk Driving. It's a nonprofit organization that does 2 things. One is it really strongly advocates for the harshest penalties for DWIs. And the other thing they try to do is increase public awareness about the devastating impacts of DWI and what can happen to victims and their families as a result of somebody driving drunk. It was their advocacy that changed a lot of laws in most of the states regarding DWI. And in 1984, every state raised their drinking age to 21. Prior to 1984, some states were 18, some were 19, some were 21, and in 1984, every state went to 21. That was because the federal government proposed it to the states as a choice. You can change your drinking age to 21 and get billions of dollars in federal highway money to repair and construct roads, or you can keep your age whatever it is and pass on billions of dollars. And of course, every state raised their age to 21 in 1984. DWI penalties we talked about, there are a number of penalties that can be projected onto you if you are convicted of a DWI or if you plead guilty. They range from getting a substance evaluation. Of course, jail time is possible if you've reached that level of offense. It can become possible for you to obtain auto insurance. It's most likely going to be in the media. There's an awful lot of penalties for DWI. It is something that has changed drastically since the past 100, since the repeal of prohibition. So back in the 1970s, if you got pulled over and you were drunk, an officer might give you a lecture, give you a verbal warning, tell you to go sleep it off. You probably wouldn't even get a ticket. Well, that changed in the 1980s when Mothers Against Drunk Driving started advocating for change to much stricter laws. And now New York State has some of the strictest laws in the country about DWI. Albany County has particularly strong policies at their DA's office. So, for example, I know that some attorneys who do DWI defense work will not represent people in Albany County because there are so few opportunities to plea bargain. There's really nothing attorneys can do for you if you get a DWI in Albany County. Just a little warning there. New York State also passed what is commonly referred to as Leandra's Law. That's the common name of the law. It's actually a section in the New York Vehicle and Traffic Law. So it is an actual statute, but we commonly refer to it as Leandra Law. This happened in 2009. A man was driving drunk. He had a bunch of kids in his car. He lost control of the car, and 11-year-old Leandro Rosado was killed in that accident. Unfortunately, that is an actual picture of that scene. And advocates for stricter and stronger DWI penalties as a result of this case persuaded the New York State legislature to create a new crime involving driving with children in your car while you're drunk. It couldn't be drunk, could be intoxicated by any type of drug. So the Leandra's Law is that anyone driving with a child 15 or younger with a blood alcohol concentration of BAC of 0.08 or over is automatically charged with aggravated DWI, which is an E felony. So if you were just over the limit, say you had a 0.09 and were arrested for DWI and there was a child 15 or younger in your car, that is an automatic E felony. Many counties will not plea bargain or in any way agree to lower that offense. Albany County, right on its website, specifically says it will not plea bargain or lower a Leandra's Law offense. So if you are charged with this crime in Albany County, you are going to be convicted of an E felony. It's almost certain. Miller v. California. We talked a little bit, not too much, about obscenity in the United States and what is considered to be pornography. And Miller v. California was the decision that came from the U.S. Supreme Court that instructed us how to determine whether or not something's obscene. And they use what they call the Miller test, of course, named for the case, or it's also referred to as the three-prong obscenity test. So if something, whether it be a photograph, a painting, something in a magazine, something on a website, if it meets these three elements, then it is determined to be obscene. Of course, it's really hard to use this test sometimes, right? So it talks about the average person applying contemporary community standards. Well, whose standards? Your community? My community? Remember when we talked about social norms, we talked about what may be acceptable in one community is completely unacceptable in another community. So it's not the best test, but it is the test that the Supreme Court gave us. So if you are asked to determine whether or not something is obscene, and therefore maybe it can't be shown on network television, or it can't be purchased by somebody under 18, you need to apply the Miller test or the three-prong obscenity test. That has nothing to do with the topic of child pornography. We don't need to have a discussion about whether or not child pornography is legal in one place or another because it's illegal all across the United States. It's against the law to possess it, create it, distribute it, or promote it. If you remember during the early part of the semester, we talked about strict liability crimes. Those are the crimes, and there's not too many of them, but those are the crimes where no intent is required. No mens rea is in the statute. If you possess child pornography, you've broken the law. If you create or distribute it, you've broken the law, period. And we talked a little bit about how sometimes somebody arrested for this offense, usually through some sort of sting operation that the feds are doing or the New York State Police, where they catch somebody online trying to create, distribute, or engage a child into pornography. And oftentimes that person arrested will say, well, I didn't do it on purpose. It just popped up on my computer, like an ad for clothes on sale at Macy's. It just popped up. Well, it doesn't just pop up. This is very underground stuff because, of course, it is extremely illegal, if that's an actual term. It has extremely high penalties. So child pornography doesn't just pop up on your computer. Regular pornography, well, that might pop up on your computer depending on your search history, but child pornography does not. So it is not going to work as a defense to say, oh, I didn't mean to have that. It just popped up. It may be a valid defense if you were able to say, well, I lost my computer a month ago and I haven't seen or used it in a month. And if that was downloaded on my computer in the last month, I could not have done it because I wasn't in possession of my computer. If you could prove that, that could be a valid defense. If you could prove someone else used your computer and downloaded child pornography or distributed it, that may be a valid defense. But the old, oh, geez, it just popped up, I wasn't looking for it, that's not going to be a valid defense. Child pornography cases are almost, shouldn't say almost always, are frequently charged under the federal statutes. The federal statutes have the highest penalties for child pornography. So say a crime involving child pornography in New York State might give you a 15-year prison sentence. On the federal system, it will give you a 35-year to life sentence. So oftentimes, if the information has been exchanged on the internet, which automatically means it has crossed state lines, that can lead to federal charges. Remember, you can be charged, I shouldn't say you, anyone can be charged both in federal court and state court for the same act. And child pornography is frequently prosecuted both at the federal and the state level. Intimate partner violence, which is also called domestic violence, involves criminal acts of abuse committed by one intimate partner to another. So this does not involve strangers, is the point I'm trying to make. So if you were walking down the street and a stranger came up and punched you in the face, they can't be charged with intimate partner violence. That's an assault, right? So intimate partner violence involves people who are currently in an intimate relationship or who used to be in an intimate relationship with each other. Domestic violence, intimate partner violence takes many different forms. It could be forced isolation, economic control, verbal or emotional abuse. You can see the list there. Now, you can't be criminally charged for verbally abusing someone. There's no such crime. You could be charged for harassment. Okay, so the crime is not coercion or threats. That's one of the types of domestic violence. In the United States, it is important to remember that 33% of women and 25% of men at some time in their adult lives become victims of domestic violence. So this is unfortunately an extremely prevalent crime. Also a very dangerous call for police officers. After intimate partner violence, we talked briefly about child abuse and neglect in New York State. As you know, this is my area of expertise, so I would have loved to have taught this for you in person. There's a lot of cool exercises we could have done about this. In 2019, our statewide hotline accepted almost 200,000 reports of child abuse and neglect, which were then forwarded to county CPS units for investigation. New York State, the standard of care for children is the minimum degree of care. That is actually what it says in the statute. It is a very low standard and simply requires parents and other people who are responsible for children to provide food, clothing, shelter, education, medical care, and adequate supervision. I called this slide New York State's failure because to me it is really problematic that New York State is the only state in the United States of America that does not have mandated reporting for elder abuse. Of course, you remember we do have mandated reporters for child abuse. That means the state legislature has declared that certain positions, people who have earned certain certificates or licenses from the state of New York, have a requirement, a legal obligation to report child abuse or neglect. However, no such thing exists in New York State for elder abuse, even though every other state has created these laws. We talked about 2 public order crimes. It's critical that you can differentiate them because the penalties are much different. So disorderly conduct, what you hear frequently on TV called discon, is when a person with an intent to cause public annoyance or alarm exhibits certain types of behavior listed here, like fighting, using obscene language, refusing to leave when a police officer has told you to leave a scene. That's disorderly conduct. That is a violation, so you know that means it's not a crime. If you're charged with disorderly conduct, it will be resolved by you probably paying a fine. Maybe you'll have to do community service. However, you will not have a criminal record. That's very different from obstructing governmental administration, often called obstructing justice. That's when someone intentionally obstructs, impairs, or perverts the administration of law, or prevents or attempts to prevent a public servant from performing an official duty. That's a Class A misdemeanor. So this comes up, and notice that it says governmental administration. You could substitute that word for police. If a police officer is trying to do his or her job and you interfere with that, that could get you charged with obstructing governmental administration. That's a Class A misdemeanor, and that's a crime. From our lecture from April 8th, Part 2, there's really just a couple of terms that you have to be familiar with. Perjury, contempt. Contempt is broken into 2 subsections, civil contempt and criminal contempt. Escape and bribery. That information is pretty clear-cut and very straightforward in the textbook, so I won't spend too much time on it here, but you do need to know this material for your final. And then we spent some time on the justification defenses. I'm sure you remember this is just a couple of weeks ago. There are 7 justification defenses: self-defense, defense of others, castle laws, duress, mistake of law, mistake of fact, and entrapment. For the final exam, it is important for you to be able to distinguish castle laws from stand your ground laws. Those are 2 different things. And it's important for you to know that New York State has a duty to retreat. Any questions about that, send me an email. You have to be able to distinguish those things. On one of our quizzes, there was a lot of confusion between mistake of fact and mistake of law. Mistake of law means that a governmental official, for example, an IRS agent or a Department of Motor Vehicles employee, someone who works for the government tells you something's legal, so you follow what they said, and it turns out it's illegal and you get arrested. The example we used on the quizzes was you're getting ready to file your taxes. You call the IRS and say, "Hi, can I deduct my lottery tickets as a business expense?" And the IRS agent says, "Sure, you're allowed to do that." So you go ahead and do it. And then you get arrested and charged with tax fraud. Your defense would be mistake of law. Make sure you understand it has to come from a government official. If you ask your roommate if it's okay to drive 120 up the Northway and your roommate says, "Oh, totally, that's legal now," and you do it, there's no defense of advice from the roommate. That's not on the list. That advice has to come from a government official, a police officer, an IRS agent, somebody who works for the government. Mistake of fact is really difficult to give you examples for because it so infrequently applies. A mistake of fact means you got an essential fact wrong, and because you were wrong, you violated the law by accident. And the only examples you'll find in textbooks are usually things like your spouse was on a trip on a plane, the plane crashed, you're informed that there was no survivors of the plane crash. A couple of years later, you get married to somebody else. If you were charged with bigamy, which is the crime of being married to more than one person at a time, your defense would be mistake of fact. It was reasonable for you to believe your first spouse was deceased. So therefore, although you may have technically committed bigamy, you did it because you were wrong about the facts. Another example, and I think the one in the textbook, was about you start a sexual relationship with someone and then find out through Ancestry.com that they're actually your sibling. If you were charged with incest, your defense would be mistake of fact. You had no idea this person was related to you. And I know those examples sound kind of silly, but that's how extreme the situation has to be. What does not work for mistake of fact is, oh, I didn't know that was illegal. I just got to this country yesterday and I didn't know that was against the law here. That's legal where I'm from. That doesn't work. That's not a defense. You are expected to know and understand the laws of where you live. Mistake of fact means it was reasonable for you to get one of the facts wrong. It's very rarely applicable to any situation. The capacity defenses are infancy, intoxication, and insanity. So altogether, you have 10 defenses that we covered. Justification defenses, which is saying, yes, I committed the crime, but I have a legitimate reason. And capacity defenses are related to really mens rea. For some reason, you weren't able to form the intent. You couldn't do something intelligently or knowingly because you were too young, too intoxicated, or too insane to form the required intent. Notice, competency is not on this list. Competency is not a defense. Competency comes up before you ever go to trial. So if someone's been arrested and charged with a crime, and they're brought to their arraignment, they're brought to their initial appearance, they either have an attorney or an attorney is assigned to them, and it becomes very quickly apparent that this person has an extreme mental health issue. They are not able to communicate with their attorney. When the attorney asks them questions, they say answers that don't make any sense. They literally will not communicate at all. The attorney meets with them over and over and over again, and they will not speak. All of these are indications that this person cannot help their own defense. They can't assist their own attorney in creating a defense for them because they're so mentally ill or having such a mental health breakdown. That's competency. What it means is you can't go to trial. So that's why it's not a defense. Defenses are used at trial. Competency says you can't even go to trial. This defendant isn't even competent to go and have a trial, even with an attorney, because he or she can't communicate with their attorney. So if a person is found to be incompetent to stand trial, what happens? They've been charged with a crime. The prosecution believes they have enough evidence to prove that crime against them beyond a reasonable doubt. And yet an expert, a psychologist or a psychiatrist, has evaluated this person and said, you can't go forward with a trial because the defendant's incompetent. Well, what happens? Well, what happens is a time frame, whichever is less of these two things. Either 18 months or the maximum sentence for the crime passes, or the prosecutor can wait and keep getting the defendant reevaluated or drop the charges. So if a person is declared to be incompetent and 18 months goes by, or the crime that they were sentenced for, whatever that penalty is, that period has passed, then this person can't be sent to trial. If the prosecutor says, well, if I keep getting this guy or this gal reevaluated, and I know one of these experts is going to eventually say this person's competent, we can go forward, well, they can wait. But something's going to happen. Either they're going to be declared to be competent, in which case they go to trial, or 18 months passes and they're still incompetent, or the maximum sentence for the crime passes, in which case they can't go to trial. So just to repeat, don't think competency is a defense. You can't have a defense if you don't go to trial. And if you're incompetent to go to trial, no defenses need to be made. A trial hasn't even begun. Now, we're going to finish up strong with the U.S. Constitution. So take a deep breath and grab your hot coffee, because here we go. The primary purpose of the U.S. Constitution is to define and limit the power of government. I am telling you right now that that is on your final exam, because I'm working on your final exam and I put that question on there. You must be able to identify the primary purpose of the U.S. Constitution, and the primary purpose of the entire document is to define and limit the power of government. We started our conversation about the Constitution with two really old-fashioned terms, Bill of Attainder and ex post facto law. You need to know what both of those things are. And in Article 1, Section 9, both of those things were prohibited. The Bill of Rights, which is the first 10 amendments to the Constitution, were added in 1791, just a couple of years after the Constitution was ratified. Remember, we had a brief conversation about some of the states didn't want to ratify the Constitution because issues like freedom of the press and freedom of speech hadn't been addressed. So they did what they called the Massachusetts Compromise. And that's where the states that had agreed and the framers of the Constitution promised those states if they ratified the Constitution, they would add what they called the Bill of Rights, which would address those issues. First Amendment, freedom of speech and the right to assemble peacefully and protest. Second Amendment, right to bear arms. Skip to the Fourth Amendment. That's where search and seizure and warrants is addressed. Fifth Amendment, we covered in this class the protection against double jeopardy, and that you cannot be forced to be a witness against yourself, what we commonly refer to as self-incrimination. And the Sixth Amendment has a whole bunch of stuff in it. Speedy and public trial, that your trial will be held where the crime was committed, notified of the charges against you, you have a right to confront witnesses, you can call witnesses to testify on your behalf, and you have a right to counsel. Yes, I can hear you asking me, you need to know which rights are in which amendment. Yes, the answer to that question is you do. Let's start our conversation about the Fourth Amendment with reasonable searches. So we talked about two different types of cases. One was there was a huge marijuana field and the police flew over it in their police plane. And while they were flying around, they took photographs of this huge field of marijuana. They landed, they arrested the homeowner for this illegal marijuana growing operation. And that defendant's argument was, well, that's illegal because you didn't have my permission to fly over my land and take pictures. And I didn't give you permission to do that. And since I own this land, that's a violation of my rights. And the Supreme Court said, yeah, we're saying it's legal. So the Supreme Court declared open fields can be searched by the police without a warrant and without your permission. It is an open field. If you ask me, well, how many acres is an open field? If you have a really big backyard, is that an open field? Well, the Supreme Court never said how many acres, how many square feet is an open field, but you should imagine bigger than your average backyard. So if the police fly over your house and you have kind of any kind of a yard, they can take photos of it. Just presume that you have no privacy to anything that's out in the open on your private property, and they call it open fields. So if you have an illegal marijuana growing operation, the police can fly over it and take pictures, and they can use those pictures against you. Same law applies for abandoned property. If you leave your trash at the curb for pickup, the police can come up and pick up your bag of trash and search through it. And if there's evidence of a crime in that, they can use that against you. So open fields and abandoned property are reasonable searches. Since they're reasonable searches, the police don't need a warrant and they don't need your permission. The Fourth Amendment, in its original form, says that the right to be the people to be secure in their persons, houses, papers, and effects against unreasonable searches. The Fourth Amendment dictates what police have to do to conduct an unreasonable search. Open fields and abandoned property, that's reasonable. So the Fourth Amendment doesn't apply to those. The Fourth Amendment applies to unreasonable searches of your person, house, paper, or effect. So we broke down the analysis this way. First, we talked about search. The Fourth Amendment does not apply to reasonable searches. What are two examples of reasonable searches? I hope you're saying open fields and abandoned property. So let's say it's not an open field or abandoned property. Let's say it's your house. Well, if a search is unreasonable, the police must either, 1, get a warrant based on probable cause, or they have to have a valid exception to the warrant requirement. How do we know they need probable cause to get a warrant? Because the Constitution says so. The Fourth Amendment says, and no warrants shall issue but upon probable cause. So the evidentiary standard to obtain a warrant is probable cause. So if the police want to conduct what's been determined to be an unreasonable search, they either have to get a warrant based on probable cause, or they have to have a valid exception to the warrant requirement. If the search is unreasonable and the police don't have a warrant and no warrant exception applies, then they have violated the Fourth Amendment. Same analysis applies to seizure and arrest. Seizure is usually used to describe the police taking something that belongs to you, a physical item. But seizure can also mean taking you and your body under the arrest, right? So seizure could mean seizing a personal item, a tangible object, or arresting your person. Again, the Fourth Amendment does not apply to reasonable seizures or arrests. We use the example if a police officer is talking to you and you punch her in the face, she can arrest you. She does not need a warrant. That is a reasonable arrest. If the police want to seize an item or arrest a person, the police must either get a warrant based on probable cause or have a valid exception to the warrant requirement. It's the same analysis. If the police seize something or arrested a person without a warrant and no warrant exceptions apply, the police have violated the Fourth Amendment. And when we talk about this live, students always ask about, well, I was watching live PD and I watched police officers arrest people over and over and over again without a warrant. Well, one of the exceptions to the warrant requirement involves automobiles, right? So oftentimes when you watch those shows and somebody's getting pulled over and arrested, automobiles really create a lot of exceptions to the warrant requirement. So that's one reason. So the police want to conduct an unreasonable search. They want to search someone's house or someone's business or someone's cell phone. They want to search through that, or they want to take something that belongs to somebody. So they got to get a warrant. So in order to get a warrant, the police officer must go before a magistrate. A magistrate is kind of a judge. We could also say go before a judge. They must articulate the probable cause. That means they can't just say, Judge, I have probable cause. They have to explain it. They have to explain what they investigated, what they found, what they were told, who told them something. They have to swear or affirm the information they're providing is true. And then they have to specifically describe the place to be searched, the person to be arrested, or the item to be seized. And why do they have to do that? Because that's what the Fourth Amendment says they have to do. It says they have to swear or affirm. They have to have probable cause. It has to be granted by a judge or magistrate. And that the police officer has to particularly describe, that's the word used in the amendment, particularly describe the place to be searched, the person to be arrested, or the item to be seized. So why do the police have to be so specific? Because the Fourth Amendment requires particularity. If the police officer cannot articulate probable cause, when they say, well, I have probable cause, and the judge says, well, what do you have? And they say, well, I just know, I just got this feeling. I've been a cop a long time, and I just got this feeling. Well, no, that's not probable cause. The judge is not going to give them a warrant. If the officer can't specifically describe the place or the person or the item, they can't get the warrant. The judge is going to say, no, go investigate and get more information, and when you have it, come back to me. The exclusionary rule is not in the Constitution. You can read the entire Constitution from beginning to end, and you will not find anything that says exclusionary rule. This is a rule that was created by the courts to address when a police officer violates someone's rights to obtain evidence. What the exclusionary rule says is that if the police violate any constitutional right to get evidence, the judge will exclude it. And the primary purpose of the exclusionary rule is to deter police misconduct. We want police officers to follow a law. We want the police to conduct their investigations in compliance with the Bill of Rights. So what do we do if they violate the rights to get evidence? We have the judge exclude it. This deters the police from getting evidence in violation of the Constitution. And does it also mean if the police make a mistake, a guilty person could go free? And the answer to that question is yes, that's exactly what it means. Fifth Amendment. We covered 3 parts of the Fifth Amendment: the right to a grand jury, double jeopardy, and protection from self-incrimination, which is the same thing as saying the right to remain silent. Grand juries we didn't spend too much time on, but you have to know New York State does use grand juries. Double jeopardy, protected from self-incrimination. The right to remain silent is in the Fifth Amendment. That's easy to remember because people say, I plead the Fifth. Double jeopardy. The prosecution did not prove its case by proof beyond reasonable doubt, so the jury acquitted the defendant. He or she cannot be tried for the same crime. So this means a prosecutor took a case to trial. The jury heard all of the evidence and all of the testimony and got to view all of the witnesses. And they went to deliberate and they said, the prosecutor did not prove this case by proof beyond reasonable doubt. When they've made that decision, they have to acquit the defendant. When a jury has acquitted a defendant, that person cannot be tried for that same crime again. Even if after their acquittal, the handcuff comes off and they run out of the courthouse and they run up to the media and they say, I did it, I frickin' shot that guy. The police cannot handcuff them and drag them back in and start the process over and go back to trial. Because if a jury has determined the prosecutor has not proved its case by proof beyond a reasonable doubt, that person cannot be retried for that same crime. Of course, for every rule, there are exceptions, and there are exceptions to double jeopardy. If the jury couldn't decide at all, if they could not reach a decision, then that trial can happen again. That jury can be dismissed. We get another jury. We start all over again. But that's because the jury was deadlocked or a hung jury. They couldn't make a decision. That can cause someone to be tried again for the same crime. If the defendant appeals their conviction, so the jury finds them guilty and they appeal to the higher court, if the appeals court says something was wrong, their rights were violated in some way, the correct process wasn't followed, this person needs a retrial, well then of course that defendant's going to be tried for the same crime twice, right? Because the court has ordered it. And remember, we talked about earlier when we were talking about child pornography, that for all crimes, you could have both a state and a federal trial. So you could face federal charges in federal court, and for the same crime, you could be facing state charges in state court. That is not a violation of double jeopardy. Protection from self-incrimination. The Fifth Amendment protects you from the police forcing you to give a self-incriminating verbal or written statement. So remember, the protection is against self-incrimination. It's in essence the police making you be a witness against yourself. It's making you tell on yourself, right? And the Constitution says the police cannot be allowed to force you to do that. So a statement is incriminating if there is a substantial and real threat that the information may lead you to be criminally charged or could establish a link in the chain of evidence that leads to a criminal charge. In essence, it connects you to a crime. That's an incriminating statement. So while being questioned by the police, if you say, I hate Netflix, I never watch Netflix, and anyone who watches Netflix is an idiot, well, that's not an incriminating statement. That has nothing to do with a crime. That's your personal opinion. But if you were to say, I watch Netflix and I don't pay for it, well, that could be a theft of services. So that's an incriminating statement. So an incriminating statement either directly or indirectly connects you to a crime. And the police cannot be allowed to force you to give those types of statements to the police and essentially make you be a witness against yourself. But the Fifth Amendment protection from self-incrimination doesn't apply to non-testimonial evidence. So remember, the self-incrimination protection is for written or verbal statements. It prevents the police from forcing you to verbally confess or to write a confession on a piece of paper. It does not apply to your handwriting sample, your fingerprints, making you appear in a lineup, and then the victim goes and says, that's the guy, and points to you. You're not protected from that. Trying on a piece of clothing to see whether it fits or not, walking in a straight line, standing on one foot, field sobriety test, DNA samples, tattoos or scars, taking and showing your photograph to people. All of those items can incriminate you. Absolutely. Some of those items are the best proof you can have in court, right? Like a DNA sample. But the Fifth Amendment protection doesn't apply to those. The Fifth Amendment only protects you from the police forcing you to write a written confession or a written incriminating statement, and it protects the police from forcing you to verbally connect yourself to a crime. If you refuse to provide or cooperate with any of these other items, not only can you, if you refuse, they can use that against you in court. For example, you get pulled over for DWI, you refuse to do the sobriety test, you refuse to do the breathalyzer, you could be charged with DWI, and when they go to court, the police officer can be on the stand and look at the jury and say, well, I offered him the field sobriety test, but he refused. I tried to get a breathalyzer to see what his blood alcohol concentration was, but he refused to give it to me. So your refusal to cooperate producing these items can be used against you in court. Sixth Amendment, awful lot here, I know, but you got to know where this stuff is located. Speedy and public trial, impartial jury, that your trial is held where the crime is committed. Of course, that doesn't mean at the crime scene. That wouldn't be right. It means in the city, the county, the region where the crime was committed. That you have the right to confront witnesses against you, that you have to be informed of what you're accused of, which in common language means being told what you're criminally charged with, calling witnesses to testify on your behalf, and that you have a right to an attorney. Well, the Fifth and the Sixth Amendment is really hard to talk about separately because they kind of combine. Your right to remain silent and your right to an attorney coalesces in the Miranda warning. We talked about how Miranda v. Arizona went all the way up to the Supreme Court, and the Supreme Court ruled in that case that you have to have a verbal explanation of your rights when you are in police custody and before they interrogate you. So once you're in police custody, if the police are going to interrogate you, which means talk to you about the crime, before they start questioning you about the crime, they have to give you the Miranda warning. And the legal word we use is triggered. The Miranda warning is triggered when you're in police custody before you're interrogated. Because, right, it doesn't work if they interrogate you and then give you the warning. So you have to get the warning before. So what does in custody mean? Of course, if you're arrested, if a police officer tells you you're under arrest, you are in custody. You are not free to leave once a police officer says you're under arrest, even if they don't handcuff you. If they've got you outside of your car and they say you're under arrest and you're standing there with your hands free, you are not free to run away. And if you do run away, the police will catch you and now you'll be charged with fleeing. Right? So if police tell you you're under arrest, you are in custody. If they want to question you about a crime, they have to give you the Miranda warning before they question you about the crime. But in custody doesn't just mean you've been arrested. It could mean any situation when you are in the presence of the police and you do not feel free to leave. To determine if a person's not free to leave, the test we use is the totality of the circumstances. So if someone argues, my Miranda rights were violated because I was in custody and they didn't give me the Miranda warning before they interrogated me, the relevant question is, well, what do you mean you were in custody? How were you in custody? Were you arrested? No, I was not under arrest. Well, then how were you in custody? Well, I didn't feel I could leave police presence. We had two examples of that. The first case, remember the guy's in bed, sound asleep at 4 a.m, and his landlady lets the police into his room, and one officer standing by the door, one sits on his bed, and another one's kind of pacing around, and they start questioning him about a crime. Well, the Supreme Court ruled in that case that the guy in his own bed was in police custody. He was not free to leave. And therefore, before the police questioned him, they were required to give him the Miranda warning. So they said, you can be in police custody in your own bed. But we also had the case, which is sort of the opposite, where the police asked someone to voluntarily come to the police station and talk to them about a crime. And the person said, sure, no problem. And they drove themselves to the station. And the police officer looked them right in the face and said, you're not under arrest. And they said, yeah, sure, no problem. They sat down, they started talking to this guy about a crime, and he actually confessed to something. Well, when he was convicted, he argued, well, my Miranda rights were violated because I was in a police station, and before they questioned me, they were required to give me the Miranda rights. And the U.S. Supreme Court said, no, just because you're in a police station does not mean you're not free to leave. You went to the police station voluntarily. The police officer told you you weren't under arrest. The door was wide open. You could have just gotten up and walked away at any time. So you were not in custody and therefore not entitled to the Miranda warning. And how to invoke your Fifth or Sixth Amendment rights. Invoke is another way to say claim. Like I'm claiming my Fifth or Sixth Amendment rights, but we use the legal term invoke. How to invoke Fifth or Sixth Amendment rights. We talked a lot about how if you want to invoke your Fifth Amendment right to remain silent or your Sixth Amendment right to an attorney, you have to do so unequivocally, which is another way of saying clearly or obviously. So if you are in police custody and you say, I don't want to talk to police, I want to remain silent, I'm pleading the Fifth, or something else that's that clear and obvious that you're claiming your right to remain silent, then you have invoked your right to remain silent, and the police cannot keep interrogating you about the crime. Likewise, if you want to invoke your Sixth Amendment right to counsel, you are in police custody, you must say, I want an attorney. Get me a lawyer. I need a lawyer. I won't talk until an attorney is present. Your statement must be clear and obvious. Remember, if you just sit there, we talked about you just sit there with your lips closed, that is not invoking any of your rights. So the police can keep interrogating you. If you clearly invoke your right to remain silent or your right to an attorney, the police must stop interrogating you. If you do not clearly invoke your right, the police can keep interrogating you. And remember, your Fifth and Sixth Amendment rights are applicable once you've been arrested or you are in police custody and not allowed to leave. If the police walk you up on the street and say, hey, where are you coming from? You can't say, I'm invoking my right to plead the Fifth Amendment, because you're not under arrest. You're not even being detained. You can just walk away. So if you've been arrested or you're otherwise in police custody, that's when you can invoke your Fifth or Sixth Amendment rights. If you get pulled over for speeding and the officer says, do you have insurance? You can't say, I'm invoking my Fifth Amendment right. You haven't been arrested. You're not in custody. You need to turn over your insurance papers. All right, last couple reminders about the final exam. The exam is next Wednesday, May 13th on Blackboard. If you open our course Blackboard page, go to the main menu, you will see an item called Final Exam. It's not there right now because it's not time to take the exam, but you will see that pop up on that menu. You must start the exam at 6 p.m. next Wednesday. You must submit it by 9 p.m. So you have 3 hours to complete the exam. You are taking this exam on the honor code, and I expect you to honor that, which means you're only allowed to use your own brain to take the exam. If you want to have some blank notebook paper or scratch paper next to you to put down things you want to remember or a list of things you've memorized in the right order, that's totally fine. You can use that. But you cannot use your textbook, your phone, the Google machine, notes, or any other materials. Okay? This is your brain only. And the format's going to be 75 to 100 questions. I have not completed your exam yet, so I'm not trying to be cagey. I actually don't know, but it will be between 75 and 100 questions and look just like the quizzes you've already taken. Multiple choice, write in the answer, true, false, matching, etc. And last reminder is when you complete the final exam and you submit it, it will give you a score. Remember, you can go to the right side of that screen, scroll down, and you'll see an OK button. If you press that OK, it's going to give you part of your score. Because remember, when you have to write in answers, say, for example, the question is, in which amendment is search and seizure addressed? And there's a blank box. You need to write in that box fourth. Well, some of you may write 4th. Some of you may write FOURTH. Whichever way you write it, Blackboard's kind of sketchy about that. So after you complete your exam, I need to go in and manually look at your answers and give you all the credit that you've deserved for those written answers. So although Blackboard will give you a score, know that that may not be the final score because I need to go in and manually correct it. I really enjoyed teaching you folks this semester. I am incredibly sorry about how we were impacted by COVID-19 and not being able to meet in person. I'm really, really glad that you stuck with it to the end. I know it was not easy to do that for this class or any other class you're enrolled in. I really hope if you haven't registered for fall classes already that you will get that done soon. And I'd love to see any one of you in any of my classes in the future. So take care and good luck.